Okay, we're going to read Manduley versus Superior Court of San Diego County. This is a 2002 case, and George is the justice who provided the opinion, starting with Proposition 21, titled the Gang Violence and Juvenile Crime Prevention Act of 1998, and approved by the voters of the March 7, 2000 primary election. Proposition 21 made a number of changes to laws applicable to minors accused of committing criminal offenses. As relevant here, the initiative measure broadened the circumstance in which prosecutors are authorized to file charges against minors 14 years of age and older in criminal division of Superior Court rather than in the juvenile division of that court. Welfare and Institution Code Section 707, subsection D, Section 707D confers upon prosecutors the discretion to bring specified charges against certain minors directly in criminal court without a prior adjudication by the juvenile court that the minor is unfit for a deposition under the juvenile court law. Petitioners are 8 minors accused of committing various felony offenses. As authorized by Section 707D, the people file charges against petitioners directly in criminal court. Petitioners demur to the complaint, contending that Section 707D is unconstitutional on several grounds. Superior Court overruled the demurs, but the Court of Appeal 4th Appellate District issued a writ of mandate directing the Superior Court to vacate its ruling and to sustain the demurs. The Court of Appeal, by a 2 for minors found to have committed criminal offenses. In considering the validity of the Court of Appeal's decision, we emphasize that this court is not confronted with any question regarding the wisdom of authorizing the prosecutor rather than to decide whether a minor accused of committing a crime should be treated as an adult and subjected to the criminal court system. In the present case, rather, we must decide whether Section 707D satisfies minimum constitutional requirements. We are not called upon to resolve the competing public policies implicated by the measure considered by the electoral when it voted on Proposition 21, as discussed at length in the by numerous amici curiae who have filed briefs in support of petitioners or the people. As we shall explain, we conclude that a prosecutor's decision to file charges against a minor in criminal court pursuant to Section 707D is well within the established charging authority of the executive branch. That sounds like they're holding. That's their conclusion, so they say. Our prior decisions instruct that the prosecutor's exercise of such charging discretion before any judicial proceeding is commenced does not usurp and exclusively judicial power, even though the prosecutor's decision effectively can preclude the court from selecting a particular sentencing alternative. Accordingly, we disagree with the Court of Appeal's conclusion that 707 is unconstitutional under the separation of powers. So, the appeal court found 21 and stat unconstitutional. You can kind of read why, but the Supreme Court is going to reverse. The state Supreme Court. Anywho, moving on. As discussed below, we have reached the following conclusions with regard to these questions. 1, the absence of a provision requiring that a judicial fitness hearing take place before a minor can be charged in criminal court pursuant to Section 707 does not deprive petitioners of due process of law. And 2, prosecutorial discretion to file charges against some minors in criminal court does not violate the Equal Protection Clause. It sounds like there's a judicial fitness hearing taking place before a minor can be charged. So that's one to note. It's the issue a little bit different. That sounds like a procedural safeguard. So I want to say, reading these conclusions on issues as issues, I'd say hearing sufficient procedural, like substantive due process procedural safeguard. It sounds like it is. And then violative, I'll say violative of equal protection and they're deciding it's not. So petitioners demur to the complaint, contending that the section is unconstitutional on a number of grounds. First, the petitioners claim that the section violates the separation of powers doctrine by vesting in the district attorney the discretion whether to file specified charges against minors 14 years of age and older in either the juvenile division or the criminal division of the Superior Court. Petitioners further contended that this section deprives them of due process of the law because the statute does not provide for any hearing to determine whether they are fit for a disposition under. Okay, so this is kind of like, is the judicial fitness hearing required substantive due process safeguard? And the answer was no. And then the second answer was no to equal protection. Okay. Petitioners also claim that the section violates the right to uniform operation of the laws and equal protection of the laws because it permits two classes of minors charged with the same crime to be treated differently at the discretion of the prosecutor. The Supreme Court overruled the demurs. That's the Superior Court. So demurs overruled. The Superior Court overruled them. The court concluded that the section does not violate the section of powers doctrine because the decision whether to charge crimes lies with the traditional power and discretion of the prosecutor. Superior Court also concluded that no due process right to a hearing exists in these circumstances, that the statute does not create any classes in which similarly situated individuals are treated disparately. That Proposition 21 does not violate the prohibitions against cruel and unusual punishment. In a divided decision, the Court of Appeal held that the section violates separation of powers doctrine. Is available to the court. We begin our analysis of petitioner's challenge to Section 707 by reviewing relevant provisions of the juvenile court law and then describing the pertinent changes affected by Prop 21. The law, apart from the provisions of Prop 21, provides that except otherwise specified by statute, any individual less than 18 years of age who violates a criminal law comes within the jurisdiction of the juvenile court, which such an individual, a ward of the court, a minor accused of a crime is subject to the juvenile court system rather than the criminal court system unless the minor is determined to be unfit for treatment under the juvenile court accused of certain serious crimes. For example, when a petition is filed alleging that a minor 16 years of age has violated criminal law and should be adjudged a ward of the juvenile court, there's the unfit for treatment, and then there's the serious crime elements of this. Yeah. Upon motion of the prosecutor, after an investigation and report by a probation officer that a minor would not be amenable to the care, treatment, and training program available to the facilities of the juvenile court, Section 707, subsection A1, in assessing the minor's fitness for treatment under the juvenile court law, the court considers the minor's degree of criminal sophistication, whether they... So, like, are we having this fitness hearing or not? A minor. So these are the safeguards, I think. Fitness for treatment, including analysis of the degree of the criminal sophistication, whether the minor can be rehabilitated, gravity of the alleged offense. So previous attempts to rehabilitate and the gravity of the offense. A minor, 14 years of age or older, who is alleged to have committed one of the serious crimes specified in the Section 707, subsection B, such as murder, robbery, assault, with a firearm, is presumed not to be a fit and proper subject for treatment by the juvenile court law. Giving the citation at the juvenile court hearing to determine the question of fitness for treatment of minor accused of such crime as a burden. Minor accused of such crime, rebutting the presumption by a preponderance of the evidence. The minor is declared not to be fit and proper subject for treatment under the juvenile court law in accordance with the foregoing statutes, criminal procedure. Proposition 21 provides the juvenile court law to broaden the circumstances in which minors 14 years of age and older can be prosecuted in the Section 707D as amended by the initiative, authorizes specified charges against certain minors to be filed directly in a court of criminal jurisdiction without the judicial determination of unfitness under the juvenile court law. So the hearing is improper, that serious offenses offenders that minors charged with serious offenses are not afforded judicial fitness hearing available to other minors, which are said the ward and the others being rehabilitatable, I think, were the classes of 3 in total. So anyway, let's keep reading. As amended by the initiative authorized, the statute sets forth 3 situations in which the prosecutor may choose to file an accusatory pleading against a minor in either juvenile court or criminal court. When a minor 16 years or older is accused of committing one of the violent and serious crimes enumerated in section, a minor 14 years of age or older is accused of committing certain offenses under specified circumstances, and 3, a minor of 16 years of age or older is accused of committing specified offenses, and the minor previously has been adjudged a ward of the court because of the commission of a felony offense when he or she was 14 years of age or older. So I feel like this is all just like statutory construction. Is an entire page of like what is in this rule. So here's like 3 tracks, another 3 tracks. Petitioners challenge only the aspect of Section D that confers upon the prosecutor the discretion to file certain charges against specified minors directly in criminal court without any judicial determination that the minor is unfit for juvenile court disposition. We proceed to consider petitioners' various constitutional claims that Section 707D is invalid. Petitioners first contend that Section 707D violates the separation of powers doctrine by vesting in the prosecutor the authority to make a decision whether to initiate a proceeding in criminal court or juvenile court that ultimately dictates whether minors charged with certain offenses upon conviction shall be sentenced under the criminal law or receive a disposition under the juvenile court law. The exercise of such authority by the executive branch, petitioners contend, invades the exclusive power of the judiciary to determine the appropriate sentence for individuals who commit criminal offenses. We believe that the majority of the executive power traditionally vested in prosecutors to decide what charges shall be alleged and against whom charges shall be brought. This broad power to charge crimes extends, selecting the forum among those designated by statute in which charges shall be filed. Contrary to the majority of the Court of Appeal, the circumstance that such a charging decision may affect the sentencing alternatives available to the court does not establish that the court's power improperly has usurped by the prosecutor. We believe that the majority of the Court of Appeal adopted an unduly restricted review of the scope of the executive power traditionally vested in prosecutors to decide which charges shall be alleged and against whom charges shall be brought. This broad power to charge crimes extends to selecting the forum among those designated by statute in which charges shall be filed. Contrary to the majority of the Court of Appeal, the circumstance of that such a charging decision may affect the sentencing alternatives available to the court does not establish that the court's power improperly has been usurped by the prosecutor. Petitioners contend that the legislative branch constitutionality has conferred upon the executive branch, that is, the prosecutor, an exclusively judicial function of choosing the appropriate dispositions for certain minors convicted of specified crimes. Several decisions of this court have addressed similar claims. As we shall explain, these decisions establish that the separation of powers doctrine prohibits the legislative branch from granting prosecutors the authority after charges have been filed to control the legislatively is available to a court. A statute conferring upon prosecutors the discretion to make certain decisions before the filing of charges, on the other hand, is not invalid simply because the prosecutor's exercise of such charging discretion necessarily affects the dispositional options available to the court. Rather, such a result generally is pursuant to the statute. We conclude that Section 707 does not violate the separation of powers doctrine. A prosecutor's charging decision may, for example, determine whether a defendant is convicted of a crime for which probation may not be granted, or for which a specific punishment is mandated. Those familiar consequences of the charging decision have, however, never been viewed as converting a prosecutor's exercise of his traditional charging discretion into a violation of the separation of powers doctrine. We distinguish a line of decisions that invalidated statutory provisions purporting to give a prosecutor the right to veto decisions made by a court after criminal charges has been filed. Such decisions are based upon the principle that once the decision to prosecute has been made, the disposition of the matter is fundamentally judicial in nature. A judge wishing to exercise judicial power at the judicial stage of a proceeding never should be required to bargain with the prosecutor before doing so. Charging decisions made before the jurisdiction of a court is invoked and before a judicial proceeding is initiated, on the other hand, involve purely pursuant to Section 707b(d), whether to file a wardship petition in juvenile court or an accusatory pleading in criminal court is made before the jurisdiction of the court is invoked. Although prosecutor, before these tracks are decided, before the forum is picked, where's the forum? Jurisdiction. So petitioners concede that the legislative branch possesses the power to require that particular charges against certain minors always be initiated in a criminal court and to preclude juvenile dispositions for certain minors receive such a disposition is exclusively a judicial function and cannot be made by the prosecutor. And I'm going to start marking up counter arguments here. A consideration of the statutory changes affected by Prop 21, however, establishes that the legislative branch has eliminated the judicial power upon which petitioners base their claim. It is true that, so this is just wrong. Like, the legislature reduced judicial power. It is true that prior to the enactment of the section provided that the juvenile court, after a hearing, made the decision whether certain minors charged with particular offenses were fit for treatment under the juvenile court law or instead could be charged and sentenced in criminal court. Now, however, with regard to minors within the scope of Section D, the statute confers upon the prosecutor the discretion to determine whether accusations of the criminal conduct against the minor should be filed in juvenile court or criminal court. If the prosecutor initiates a proceeding in criminal court and the circumstances specified in Section D are found to be true, the court generally is precluded by statute from ordering a juvenile disposition. And so, the counter argument, rebut the counter argument, legislation subordinates judiciary power that they're suggesting. The prosecutor's discretionary charging decision pursuant to Section D, which thus can limit the dispositional alternatives available to the court, is no different from the numerous pre-filing decisions made by prosecutors. For example, assault with a deadly weapon or another form of aggravated assault, or whether to charge manslaughter or murder, or whether to charge facts that judicial power, after charges have been filed, to choose among the dispositional alternatives specified by the legislative branch. The voters, through the enactment of Prop 21, have determined that the judiciary shall not make the determination regarding the minor's fitness for a juvenile disposition where the prosecutor initiates criminal action pursuant to Section 707D. Contrary to the majority of the Court of Appeal, the circumstance that a fitness determination for minors accused of crimes within the scope of Section 707D formally was made by the court after a judicial hearing does not establish that granting the prosecutor discretion whether to file charges directly in criminal court invades a judicial prerogative. The Court of Appeal reasoned that, absent Section 707D, the determination of whether a juvenile or criminal sentencing scheme will apply requires a particularized evidentiary hearing to adjudicate the individual juvenile's fitness for suitability for juvenile court treatment, and those adjudicatory functions are essentially judicial in nature. Therefore, the court determined the decision regarding which dispositional scheme applies is adjudicatory in nature, and Section 707 allocates the judicial power and function to the district attorney in violating the separation of powers principles. The Court of Appeal majority analysis misapprehends the purpose and scope of the separation of powers doctrine. So this is a counter-argument too about separation of powers, and here's basically the refuting the counter-argument. Impermissible factors, such as discriminatory prosecution. The majority of the Court of Appeal also erred in equating the prosecutor's decision pursuant to Section 707D with the fitness determination made by the juvenile court in circumstances in which 707D applies. The statute dispenses with the requirement of a particularized evidentiary hearing to adjudicate the individual juvenile's fitness or suitability for juvenile court treatment, which the Court of Appeal deemed to be essential judiciary function that could not be delegated to a prosecutor. Section 707D grants the district attorney authority to establish and apply the criteria that guide his or her decision whether to file an accusatory pleading in criminal court. Such power is well within the district attorney's traditional executive authority. Petitioners further characterize the prosecutor's decision pursuant to Section 707D as a selection of the jurisdiction with the most appropriate sentencing scheme for a particular defendant, and they attempt to contrast such a decision with the prosecutor's well-established authority to select which crime to charge. As established above, however, the decision to charge a minor with a particular crime, like a decision pursuant to Section 707D to file charges in criminal court, can also eliminate the juvenile court jurisdiction over the matter and dictate the sentencing scheme that will apply upon conviction, and petitioners admit that the former decision properly can be exercised by the prosecutor, inasmuch as petitioners concede that the legislator possesses the authority to eliminate entirely the jurisdiction of the juvenile court and preclude juvenile court dispositions with regard to all minors who come within the scope of Section 707D, a statute conferring upon the prosecutor the discretion before a judicial proceeding has been commenced to charge some of these minors in criminal court does not usurp in exclusively judicial authority. Most prosecutorial charging decisions can circumscribe the sentencing options available in the court, and such decisions have never been considered to be analogous to fixing penalties for charged crimes or to require legislative guidelines to qualify that statement. Petitioners further challenged Section 707D on the ground that it deprives them of due process of law as guaranteed. So here's another counter argument 3. And this is deprives them of due process of law as guaranteed by the federal and California constitutions. According to petitioners, a minor accused of criminal conduct possesses statutory right to be subject to the jurisdictional court before a prosecutor may deprive a minor of that right by filing an action in criminal court pursuant to Section 707D. Petitioners contend the minor is entitled to hearing to determine, pursuant to established criteria, whether he or she is amenable for juvenile court disposition. Because Section 707D neither provides for such a hearing nor sets forth criteria guiding the prosecutor's exercise of discretion, petitioners can use a procedural fairness. The premise of petitioner's claim is false. However, because minors who commit crimes under the circumstances set forth in Section 707D do not possess any statutory right to be subject to the jurisdiction of the juvenile court. Although the juvenile court has jurisdiction over minors accused of most crimes under the statutory provisions adopted by the enactment of Proposition 21, the criminal court also has jurisdiction over those minors who come within the scope of Section 707D. When the prosecutor files charges in that court, in these circumstances, when governing statutes provide that the juvenile court and the criminal court have concurrent jurisdiction, minors who come within the scope of Section D do not possess any right to be placed under jurisdiction of the juvenile court before the prosecutor initiates a proceeding accusing them of a crime. Thus, the asserted interest that petitioners seek to protect through a judicial hearing does not exist. Just tool jurisdiction until charged. Means, okay, so that's the little 3. Because petitioners did not possess a protected interest in being subject to the jurisdiction of the juvenile court, the authority upon which they rely in support of their claim is indistinguishable. In Kent v. United States, the High Court considered the statutory scheme conferring upon the juvenile court original and exclusive jurisdiction over a minor accused of committing serious crimes. The law authorizing the juvenile to waive its jurisdiction and transfer the matter to criminal court after a full investigation, but no statutory criteria or procedures govern the juvenile court's determination to waive jurisdiction. Unlike the statute considered in Kent, California's juvenile court law does not confer upon the juvenile court original exclusive jurisdiction over minors accused of crimes under the circumstances set forth in Section 707D. Furthermore, pursuant to Section 707D, neither the juvenile court nor the criminal court renders a decision whether the minor is fit for juvenile court disposition. Rather, as we have explained, the prosecutor's charging decision determines which court shall hear the matter. Kent held only that where a statute confers a right to a judicial determination of fitness for a juvenile court's disposition, the Due Process Clause requires that the determination be made in compliance with the basic procedural protections afforded to similar judicial determinations. A statute that authorizes discretionary direct filing in criminal court by the prosecutor, on the other hand, does not require similar procedural protections because it does not involve a judicial determination, but rather constitutes an executive charging function which does not implicate the right to procedural due process and a hearing. The legislative branch properly can delegate to the prosecutor, who traditionally has been entrusted with the charging decision, discretion whether to file charges against a minor directly in criminal court, and the legislator can also eliminate a minor's statutory right to a judicial fitness hearing. Therefore, a prosecutor's decision pursuant to Section 707D to file charges in a criminal court does not implicate any protected interest of petitioners that gives rise to the requirements of procedural due process. Petitioners next challenge Section 707D on the ground that it violates their right to the equal protection of the laws because the statute permits identically situated minors to be subject to the same the juvenile court or the criminal justice system based solely upon the juvenile court prosecutorial decision that is unguided by any statutory standards. Accordingly to petitioners, the creation of two classes of minors pursuant to Section D implicates fundamental liberty interests in the disparity of treatment of minors falling within the scope of the statute is neither justified by a compelling state interest or rationally related to a legitimate interest. Therefore, they contend Section D is unconstitutional on its face. We conclude the petitioner's equal protection claim lacks merit. So, to succeed in their claim under the Equal Protection Clause, petitioners first must show the state has adopted a classification that affects two or more similarly situated groups in an unequal manner. So, they're not really meeting that burden. Even though they said it, I guess they didn't meet the burden. Petitioners do not challenge the classification expressly set forth in Section D. That is, they do not contend that the disparate treatment of minors who meet the criteria set forth in Section D and the minors who do not meet such criteria is impermissible. Instead, they assert that Section D authorizes prosecutors to create two classes of minors, both of which satisfy the criteria set forth in the statute. One class consists of those minors against whom prosecutors choose to file criminal charges in criminal court, and the other consists of minors accused of having committed the same offenses, but against whom prosecutors choose to file wardship petitions in juvenile court. These two classes are did in an unequal manner. Petitioners observe because the application of the juvenile court law or criminal law can give rise to significantly different rights and penalties under similarly situated minors. So if one gets wardship and one doesn't, are they really similarly situated? As petitioners implicitly concede, all minors who meet the criteria enumerated under Section D equally are subject to the prosecutor's discretion whether to file charges in criminal court. Any unequal treatment of such minors who commit the same crime under such circumstances results solely from the decisions of individual prosecutors rather than whether to file against particular minors in a petition in juvenile court or instead an accusatory pleading in criminal court. Claims of unequal treatment by prosecutors in selecting particular classes of individuals for prosecution are evaluated according to ordinary equal protection standards. These standards require the defendant to show that he or she has been singled out deliberately for prosecution on the basis of some invidious criterion that the prosecution would have been pursued except for the discriminatory purpose of the prosecuting authorities. This invidious purpose of prosecution is one that is arbitrary and thus unjustified because it bears no rational relationship to legitimate law enforcement interests. Section D contains no overtly discriminatory classification. In their challenge to Section 707D, petitioners do not contend that the district attorney filed charges against them in criminal court on the basis of some invidious criterion or for a discriminatory purpose, or that the Section 707D has had any discriminatory effect. Petitioners instead contend that Section 707D might result in invidious discrimination because it contains no standards guiding the prosecutor's discretion whether to file charges in criminal court. Petitioners can establish a violation of their right to the equal protection of the laws by showing that other minors in circumstances similar to those petitioners can be prosecuted under the juvenile court law. In criminal court to minors of a specified age who commit enumerated crimes under certain circumstances. And at the preliminary hearing, the magistrate must find reasonable cause to believe that the minor has committed such a crime under those circumstances. In addition, the prosecutor's decision is subject to constitutional constraints against invidious discrimination. Therefore, contrary to petitioner's contention, the prosecutor's decision is not unfettered or entirely without safeguards. The prosecutor's discretion to select the statutorily eligible cases in which to seek a criminal disposition against a minor based upon permissible factors such as circumstances of the crime, background of the minor, or a desire to show leniency, for example, does not violate the Equal Protection Clause. In support of their claim, petitioners rely on the divided decision of the Utah Supreme Court, State v. Moe. See infra blah page later in this book, which invalidated a statute conferring under prosecutors the discretion to file charges against minors directly in criminal court. The holding in Moe was based exclusively upon a provision in Utah Constitution, as the plurality opinion in Moe emphasized. However, Utah's constitutional provision concerning uniform operation of the laws established requirements different from those of the federal Equal Protection Clause. In any event, we are not persuaded by the reasoning of the plurality opinion in Moe. The opinion contrasted a prosecutor's traditional charging discretion with the prosecutor's assertedly arbitrary discretion to file charges against a minor directly in criminal court. According to the plurality opinion, traditional charging discretion concerned which law to apply to a single offender, whereas direct filing discretion involved how to apply the same law to different offenders. Because the challenge statute permitted prosecutors to treat different offenders accused of the same criminal offense differently, similarly situated juveniles, and thus violated the state constitutional requirement of uniform operation of the laws. Contrary to the reasoning of plurality opinion in Moe, however, traditional prosecutorial charging discretion, which includes a discretion not to bring any charges against a particular offender, encompasses decisions how to apply the same law to different offenders, often without any express statutory criteria guiding such decisions. Thus, the prosecutors properly may decide that some individuals who have engaged in criminal conduct prescribed by a particular penal statute should not be prosecuted at all. Prosecutors may charge some defendants with a misdemeanor violation of the statute and others with the felony violation. With regard to some offenders, prosecutors may seek the maximum penalty authorized by the statute to recommend probation or diversion for other offenders. None of these prosecutorial decisions, unless based upon invidious discrimination or retaliatory motive, ever has been considered to be unconstitutionally arbitrary. Therefore, prosecutorial discretion for operation of the laws and judgment of the Court of Appeals is reversed. So that was the long majority opinion. It's like 40 minutes in recording it. The dissenting opinion is only a page and a half. So I'm going to read that and then blow through the notes like we did the last one. Dissenting opinion by Kennard J. Historically in California, the decision whether to grant a district attorney's request that a minor be prosecuted in adult court instead of juvenile court is a function of the judiciary, a neutral body. In 2000, however, the voters of the state enacted Prop 21, an initiative measure that, among the matters, grants a prosecutor discretion. There is no guide to exercise. There is no judicial review. The last omission or reviewing the decision. This portion of Prop 21 eliminates the essential check on arbitrary executive power and thus offends the principle of separation of powers, embodied by the California Constitution. Was that so hard to say? Prop 21 seeks to eliminate the required checks and balances, but as to those minors who could be prosecuted in either adult court or juvenile court, it allows the prosecutor to make a decision that unrestrained by any legislatively prescribed standards and without judicial review. It is, if the decision is to prosecute in adult court and it later appears that the juvenile court would have been more appropriate, the minor has no remedy because the judicial branch is excluded from the determination. This portion of Prop 21, in my view, conflicts with the constitutional mandate. The juvenile court system and the adult criminal court serve fundamentally different goals. The punishment for serious crimes tried in criminal courts is imprisonment, and the purpose of imprisonment for crime is punishment. In contrast, the juvenile court system seeks not only to protect the public safety, but also the youthful offender. Section 202, Section A states that the purpose of the juvenile system is to provide for the protection and safety of the public and each minor under the jurisdiction of the juvenile court to preserve and strengthen the minor's family ties whenever possible. The practical consequences are immense. An adult court may sentence a defendant to life imprisonment. A juvenile court cannot impose confinement beyond the age of 25. Adult convictions are public and juvenile commitments are sealed, a difference that affects future employability and many other matters. Adult convictions are criminal in character and may deprive the person convicted of the right to vote, to serve on a jury, to carry firearms, and to enter certain professions. Juvenile convictions carry no collateral consequences. Finally, by filing in adult court, the prosecutor deprives the juvenile of the very rehabilitative programs available in juvenile court. So we're just talking about the importance thereof and a nexus between the discretion power. In my view, Prop 21 unconstitutionally invaded a judicial function for the following reasons. First, almost from the inception, so another separation of powers, I think. Inception of the juvenile court system in California, the decision whether a minor is unfit for juvenile court proceedings has been a judicial function. History alone may not be conclusive, but it is important for the division of authority among the three co-equal branches of government is largely a product of history. Second, whether to prosecute a juvenile in juvenile or adult court is critical and thus deserving of, that's what the paragraph above was about, and thus deserving of due process protections of the judicial proceeding. So it's a liberty interest. Got it. Do not suggest that the critically important decision whether to try a minor in adult or juvenile court should receive due process protections only if it is made after charges have been filed. Yet, if the same decision, equally important and consequential, is made before charges are filed, then, according to the majority, the prosecutor has unreviewable discretion, subject only to the most minimal of consequences, prohibiting invidious discrimination or vindictive or retaliatory prosecution. There is no judicial review to correct erroneous decisions, inconsistent decisions, or decisions that certain classes of minors or all minors will always be prosecuted in an adult court. Third, at the time of filing charges, the district attorney's office has limited information. The details of the minor's prior criminal history, if any. It may not know the minor's family, school, or community history, all matters that are important in deciding whether the minor is suitable for juvenile court treatment. It may not know the minor's view of the matter. It probably has not heard from the minor's counsel, who has yet to be appointed. There has been no hearing testimony and no receipt of evidence. As a result, the prosecutor, acting with limited information, may err in the decision, and although an error in submitting the minor to juvenile court jurisdiction is correctable, one inside minor to adult court is not. In conclusion, the validity of Prop 21's provision giving the prosecutor power to decide whether to prosecute a minor in an adult court or juvenile court turns not on the timing of the prosecutor's decision, but the substance of the power and the effect of its exercise. The power, as I have explained, is unrestrained by legislative standards and susceptible to arbitrary exercise. The effect is profound, determining whether the minor will be prosecuted in a system that stresses punishment or one that stresses rehabilitation. In the setting, the absence of judicial review brings that portion of Prop 21 into conflict with Article 3, Section 3 of the California Constitution. And last but not least, we're talking about the notes. We're going to read them by number. 1, judicial standard list prosecutorial discretion, and distinguishing it against the State versus Moe, which is the Utah case. The Utah Constitution, reading all laws, blah, 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 is a little different, I guess, than California. So they go on. It looks like they're going into the details of that case, which I don't want to misstate in this. I don't want to misstate it because the issue has something to do with the differences in the Constitution. I don't want to